Good morning, my lord. Good morning, my lord. Good morning, my lord. Good morning, my lord. Gbogbo wọn wà muted àbí báwo wọn ṣe ń pè. Good morning, my lord. Ẹ pè ń pò mú online. Good morning, my lord. Ẹ pé kó hàn mute ara wọn. Ibi tí ìgbọ̀n ta kàn, ó mọ̀ ní pé. Huh?
Registrar, go ahead and call the matter. Can you hear me?
Yes, I can hear you, my lord. Good morning, my lord.
Good morning. Yeah, go ahead.
Resume at Lagos today, Friday, 8th May 2026, before His Lordship, Honorable Justice Joyce A.O. Damachi. You are most welcome, my lord. NICN/LA/31/2024 between Bukes Eyitemi Saliu and Thelma Eyiko Sholanke. My lord, parties absent.
Appearances?
With profound respect to the Honorable Court, Fayokemi Olusegun for the claimant, my lord. My lord.
Yes.
With profound respect to the Honorable Court, Fayokemi Olusegun appearing for the claimant.
Yes, I got that. Is the defendant online? Defendant counsel online?
May the court be pleased. Your Lordship, my name is Jesse Odi, and with me is my learned friend, Odi Ayanlere, for the defendants.
Okay. Okay, so this is the ruling of the court on an application dated 4th of November 2025 brought by the claimant applicant pursuant to the relevant laws, rules of court, and under the inherent jurisdiction of this court, seeking the following: one, an order of the Honorable Court granting leave to the claimant to file additional documents in this suit. Two, the second relief is an omnibus clause. The application is supported by an affidavit of 6 paragraphs deposed to by one Olalade Babatunde, a litigation secretary in the law firm of Street Landlord Practice, dated 24th of November 2025. The applicant raised a sole issue in his written address, dated the 24th day of November 2025, to wit, and I quote, whether the Honorable Court has the power to grant the prayers of the claimant applicant in this application. The applicant's counsel founded this argument on the doctrine of fair hearing or the altering pattern, which entails that a party must not be denied fair hearing. Fair hearing is a right which ensures that every party to a dispute is given a fair opportunity to present their case and evidence before a decision is made. Counsel relied on the case of Razaki and Ajijola. He also submits that granting their claimant leave to file additional document in proof of a case will enable the claimant a fair chance at presenting its matter properly before this court, and relied on the case of Mavolo and Mariam, where the Court of Appeal held, and I quote, parties are required to prove their cases in the trial court, and therefore it is the duty of parties to produce all the necessary evidence to establish their case at the trial court, and not to prove their case partially in the court and partially in the Court of Appeal. Furthermore, End of quotation. Furthermore, counsel noted that there were discrepancies in the documents sought to be tendered by the claimant with respect to debit details of her account, which were unclear and missing some details in the course of printing, which has necessitated the bringing of this instant application to provide the court with a clear copy that is devoid of errors and omission, and backed his argument with the case of Nalsatim Associates and NNPC on the duty of the court to allow parties to correct their errors. On the strength of this authority, counsel submitted that this court has a duty to ensure that the adverse party does not take advantage of the error and omission contained in the claimant's statement of account, which was sought to be tendered. Finally, he submits that given the inherent jurisdiction of this court has the discretion to grant this application, which ought to be exercised judicially and judiciously. In reply to the application, the respondent filed the 6-paragraph counter affidavit dated 1st of December 2025, sworn to by one Tajuddin Abolade, a litigation clerk in the office of Stone Foba Law Practice, who are counsel for the defendant. The affidavit was supported by a written address of same date, 1st December 2025. The respondent's counsel formulated key sole issue to wit whether the applicant's motion on notice to file an additional document is not an abuse of court process. One of the respondent's counsel's contention is that the document now sought to be filed by the applicant was not pleaded. Counsel holds that it is tried and settled principle of law that facts or documents not pleaded are not admissible in evidence, and relied on Issa and Audu, which summarize that unpleaded documents and evidence go to no issue. Furthermore, counsel argued that parties are bound by their pleadings, and any document not pleaded cannot be smuggled into the record under the guise of an application for an order to file additional documents. Secondly, he noted that the document the applicant sought to file is a bank statement duly certified by the applicant's bank. Counsel holds that documentary evidence must be tendered in accordance with the rules of the Evidence Act or any relevant law, and cited Section 89A(h) and 91E of the Evidence Act, and contended that it is only the duly authorized official of the applicant's bank that is competent to tender it. On the foregoing principle of the Evidence Act, he relied on Ogoyene and Ogoyene, Elias and Federal Republic of Nigeria. Citations were all provided, all authorities in relation to the tendering of bank documents. Thirdly, counsel considered the idea of seeking an order of this court to file an additional document as an abuse of court process, as the document was neither pleaded in evidence nor supported by testimony of its maker, and defined an abuse of court process as one which occurs where there is an improper use of judicial process by one of the parties to the detriment or chagrin of the other, to circumvent the proper administration of justice, or to irritate or annoy his opponent, taking undue advantage which otherwise he would not be entitled to. Counsel relied on NIC and VCI Limited. Citations all provided. Finally, counsel also insists that the law requires that documents be tendered by their makers or through persons legally authorized to do so, and when the maker is unknown or absent, the document becomes inadmissible. Furthermore, he holds that in this instant case, the applicant has neither pleaded the statement of account nor produced the maker to tender it. He posited that the applicant's attempt to introduce such a document offends a clear provision of the Evidence Act and rules of court, which therefore constitutes an abuse of court process and should be rejected. He posited that this court has jurisdiction to undo what has been done by a party in abuse of the process of court to overreach and present the court with a fait accompli. Counsel cited Chess Chain and Nikon Hotels Ltd. On the fourth ground of argument, counsel submits that contrary to paragraph 4.4 of the applicant's written address, the applicant cannot legally invite this court to exercise its discretion in the favor in flagrant disregard of the law, and argued that the discretion of the court, if invoked, must be exercised judicially and judiciously and guided by the dictates of law and facts properly before the court. He also submitted that it is not sufficient for the party to merely assert that to be in the interest of justice to grant its application, and relied on the words of Umole JCA in Ezenwafo versus COP, which summarizes that the phrase, I quote, "in the interest of justice," is not a magic wand that can be hinged upon by any single party. In reply to the counter affidavit dated the 1st of December 2025, the applicant filed a reply on points of law dated 27th of February 2026 with the sole issue thus whether the applicant's motion on notice to file an additional document is not an abuse of court process. Applicant's counsel contended that the applicant has substantially complied with the requirements of section 89H and 90 1 sub E of the Evidence Act and further relied on the case of Ogoyone and Ogoyone, wherein the court held that computer printout or bank statement of account can be admitted in evidence by virtue of section 97 sub 1H and sub 2 sub E of the Evidence Act. He concluded with the submission that the court has the power to exercise discretion in the applicant's favor and grant the application in the overriding interest of justice and fair hearing. Now to the resolution. I've read all the arguments canvassed and all the evidence before me. I will restrict the issue to whether this application ought to be granted. The applicant's only and simple request before this court is to be given leave to file an additional document, which is a statement of account of the claimant for the purpose of clarifying the discrepancy in Exhibit C9 owing to unclear and missing details in the said exhibit. I will have recourse to rely on the records of the proceeding for the day of 29th of October 2025, wherein during cross-examination of the claimant, the defendant's counsel referred the claimant to Exhibit C9, which is one of the payment receipts already tendered, dated the 24th day of March 2022. I will reproduce same cross-examination here for clarity. The question went thus: look at Exhibit C9. This is one of the receipts of payment, and she answered yes. Kindly read the balance of the receipt after the payment was made, and the answer was 301,492 naira 74 kobo. The question now: how much payment did you make in Exhibit C9? And she answered, I made 3,000 naira. Look at the amount before payment was made in Exhibit C9, and the answer was 301,694 naira 84 kobo. The question again: from the answer given above, 301,694,084 kobo, there is a difference between the balance before and the balance after in less than 1,000 naira, but you made a payment of 3,000 in respect of that transaction. She answered, like I have explained before, receipts can be generated with charges, and I am appealing that the court grant me the opportunity to print out my bank statement. The next question was, should I put it to you that this document is forged because the difference between available balance and current balance is less than 1,000, while the payment made is 3,000 naira? And she answered, when receipts of payments are made, different charges reflect on the receipt. I apply that the court grant me leave to get my statement of account from GTB. In another instance, this court also noted that in Exhibit C3, the receipt for a transaction of 100,000. However, the current balance as stated was 121,695 naira 91 kobo, while the available balance is 120,725 naira 71 kobo. The summary of the above records, and also in the observation of the defendant's counsel, is that the figures do not add up in reflection of the transactions made. The claimant herself admitted to the discrepancies. As a result, the defendant's counsel arrived at the conclusion that the documents were forged. These discrepancies necessitated the bringing of this application as it would appear. The defendant's counsel is vigorously opposed to this application on the ground that the document sought to be added was not pleaded. No doubt, the defendant's counsel's position that the document was not pleaded is true. It is also correct that parties are bound by their pleadings, and evidence on matters not pleaded goes to no issue. See Reimi and Akintoye, Ayinla and Ajigun, Ogocha and Agocha citations are all provided. However, these facts relating to a document have been pleaded. The document itself may not be pleaded. In Access Bank versus Ogoja, citation provided, the Supreme Court restated this position as follows, that I quote, documents in support of pleaded facts can be tendered and admitted even though the document itself had not been pleaded. See also KK Anurum, MCC and Azubike, Okonkwo and CCB, Olasinde versus ACB, and Allied Bank and Akabs Bueze. Citations are all provided. Similarly, in Sterling Bank and Falola, citation provided, it was also enunciated thus, and I quote, it is sufficient if statement of fact relating to a document are contained in the pleadings and not necessarily that the document or piece of documentary evidence must be specifically pleaded in the party's pleading. Pleading sufficient facts relating to a document goes to show its relevance to the case of the party in question. And once there is no legal bar to its admissibility, the document is admissible. Documents in support of facts needed not be pleaded, but can be tendered in support of pleaded facts, as in the instant case. In other words, a document in support of pleaded facts can be tendered and admitted in evidence, even though the document itself had not been pleaded. This is based on the concept that a document referred to in a pleading becomes part of the deal. Salami and Union Bank, MCC and Azubike. End of quotation. The point to note here is that although the additional document sought to be added was not specifically pleaded, the facts relating to it are already before the court. The document sought to be added covers the same period of transaction and for the same subject matter as contained in Exhibit C9. More so, Exhibit C9 in question is just about the same account details as the document sought to be added. It goes to show that facts pleaded in relation to or in connection with Exhibit C9 are the same as the document sought to be added. Furthermore, the only purpose of this document sought to be added is to clarify the contents of Exhibit C9, which are already before the court and no more, especially as the defendant's counsel had alleged crime on the part of the claimant. It is my view that the document sought to be added would not introduce facts or issues which are different from those already before the court. Again, on the admissibility of bank statements, I took into consideration the brilliant submission of defendant's counsel, but it is my opinion that the question of admissibility and the argument about the tendering of admissible or inadmissible document is one this court cannot consider at this stage. The argument as to admissibility would be best left for the trial stage, as the document sought to be added is yet to be tendered. More so, this application is all about bringing an additional document as to entertain such an argument at an interlocutory stage would be putting the cart before the horse. In Adewale and Governor Ekiti State citation provided, the court simply held that a court is not entitled to make findings in an interlocutory application which would amount to prejudging the issues that would arise for determination at the trial. As it stands, this court cannot at this stage inquire into the admissibility, genuineness, correctness, evidential weight, or likewise, or success of the document sought to be added. It is more appropriate to leave issues of the admissibility of a document attached to an affidavit until hearing. Equally, the Court of Appeal held in Anduaka and Obot, and I quote, that a document in an affidavit must not be objected to until the substantive action comes up for hearing. In the instant case, the attack on the admissibility or not of Exhibit B, C, and D on grounds of non-certification as public documents at this stage went to no issue. End of quotation. Adejumo and Millard, Military Governor of Lagos State, Cross River State Development, Property Development versus Obonga, and Fawemi and IGP, Hassan and EFCC. All citations are provided. Where there is a question of the admissibility of a document attached to affidavit in an application or matter before the court, depending on the circumstances, the parties may not be able to challenge the admissibility of documents attached to the affidavit at the initial stage of the proceeding. In line with the foregoing, the mere granting of this application will not operate to make the document sought to be added as already tendered in evidence. What the court can do, however, is to look at the document, even though it was not tendered in evidence. See Agbasai versus Ebi Kufere, OAN Overseas Agencies and Bowen Energy Trading, Akinola versus VC Uniloring, and Uzodima versus Izunaso. Citations are all provided. Going further, I am of the view that the document sought to be added will be material to this case, especially because it will clarify the discrepancies which the defendants have noted. This is important for the just determination of this case and for a fair hearing of all parties. On the whole, having considered all the facts and laws and also the circumstances surrounding this application and having regard to the overall interest of justice, I find that this court can exercise its discretion in the granting of this application. More so, it is my opinion that the defendants will not be prejudiced by the grant of this application. Accordingly, this application is hereby granted. I make no order as to cost. This is the ruling of the court.
As the court pleases, my lord, we are very grateful for the well-considered ruling.
We also thank the Lordship for the ruling of the court.
My lord, in the instance of the ruling just delivered, we'll be seeking for a date to bring an application to recall the claimant to tender this additional document. My lord. My lord. I think she's cut off.